Joe, I know we're behind on the Fernlow project. You know I'm having some personnel problems. Joe, hey, hold on a second. I'm trying my best to keep production on schedule, but I've been spending so much time with Peter Nelson lately, I don't seem to have the time to keep my eye on anything else. Yeah? So, you think I ought to go ahead and fire Nelson? Yeah, I'm meeting with him in the next few minutes. I'll let you know how it goes. Sally, you can go ahead and send in Peter Nelson now. Pete, sorry to keep you waiting on a Friday afternoon.
That's all right.
I just got off the phone with Joe Fitzgerald. He's getting a lot of client complaints about service from our department. I think the reason why our department is slipping is because I've been forced to spend too much time making sure your work is done properly.
Hasn't been that bad.
Last week, Bob Wilcox needed my help on the Fernlow project. I couldn't spare the time because I was redoing your job. Now the Fernlow project's way behind schedule and we're getting flack out of New York. Peter, you've done some good work here, but frankly, you're just not working out. I'm gonna have to let you go. I'm really sorry.
What? I don't believe this. After the way I pulled your ass out on that Michigan job, you do this?
Oh, brother, come on.
Damn it, John. Do you know how long I've been with this company? What is going on?
Pete, you know as well as I do your work's been in the toilet.
It hasn't been that bad.
You haven't been worth a darn the last 3 years.
Hasn't been that bad.
I've covered for you every chance I got, and I'm tired of it. Joe's tired of it. The whole damn department's tired of it. Look, I don't have a choice, all right? You knew there was a problem. We've talked about this before.
So this is the thanks I get for 10 years of hard work?
Ah, don't be an idiot, Peter. Lately, you've been inept, unreliable. Geez, I could hire people off the street and get more out of them. I don't have time to babysit a lazy department head anymore. We're going to give you 2 weeks severance pay. Yeah, I'm sorry it didn't work out. Look, Pete, let me know when you get ready to leave, will you? I got to get your keys back and the company credit card. I'm sorry.
Yeah.
Firing an employee is an emotionally draining experience. For the person doing the firing, it's one of life's most unpleasant tasks. And for the person being fired, a termination can be a devastating blow to the ego, seriously damaging one's feelings of self-worth. Hello, I'm Tommy Cresswell. And for the next few minutes, we're going to discuss termination. You know, in the past, once it was over, and you could get back to business. But now terminations also cause legal problems, and these legal problems can have a grave impact on managers. What you're about to see is a fictitious scenario, but one that could happen to you.
Mr. Foreman, please read the verdict.
We, the jury, find for the plaintiff Peter Nelson on all counts. We award a total of $2,050,000 in damages to plaintiff. Of this amount, $500,000 represents lost wages and benefits, $500,000 represents emotional distress, and $1,050,000 represents punitive damages. We find the defendant, Zycor Corporation, liable to plaintiff in the amount of $2 million, and we find defendant John Martin personally liable to plaintiff in the amount of $50,000.
That's right. John Martin is also a defendant in this case, and you could be one too. How did John and Zycor get entangled in such a costly courtroom battle? Not only did Peter Nelson get an award of $2 million, but John Martin and Zycor will have to pay attorney's fees and the high cost of litigation. In the emotionally charged atmosphere of termination, mistakes often occur. In fact, much of the litigation involving employment issues is a result of poorly handled terminations. In this climate of litigation, there are usually two kinds of mistakes that managers make in dealing with these issues. They are either unaware of the possible legal consequences of their actions, so they may make mistakes, or they are so aware of the legal consequences that they're traumatized and fail to act decisively. We will show how you, as a manager, can terminate an employee in a manner that both complies with the law and treats the employee with dignity and respect. Now, to help us do this, we've assembled a group of experts, including a noted economist, an industrial psychologist, and several experienced labor relations lawyers. In this program, we'll look at the steps in the employment process and specifically discuss how termination and the way it's handled can subject companies and managers to risk of lawsuits. We'll also show you ways to reduce those risks. The areas we'll cover include the pre-employment interview, what to do and say and what not to say, the performance review, how to fairly and effectively review employee performance, discipline and discharge, how to terminate an employee with dignity and respect, and how to conduct yourself after termination. During this tape, we'll see how our fictitious characters react to various situations. We've intentionally chosen our plaintiff, Peter Nelson, the discharged employee bringing the suit, as a white male under 40. We've done that so that we're not complicating the situation by having someone who could also sue for age or sex or race discrimination. While you're watching the program, please remember employment laws vary in every state. In the back of the workbook is additional information on employment laws specific to your area. Now you'll see both the right way and the wrong way to handle these situations. In short, we're going to show you how to effectively manage a quality workforce.
Well, early in the century, just as employees could leave their employer for any reason, employers could terminate their employees for any reason, for a good reason, for a bad reason, or for no reason at all. That was called employment at will. Today, things are very much different. There's a long list of federal and state laws which regulate the way an employer must treat his or her employees. There's the basic labor laws, Taft-Hartley, and so on. There's the Age Discrimination in Employment Act, Title VII of the Civil Rights Act of 1964, occupational safety and health laws. The list goes on and on.
When most of these laws were first enacted, there was little risk of a jury trial, and proceedings were pretty much devoid of emotion. Awards were usually limited to back wages. In the 1960s, the Age Act provided for a jury trial, but the verdicts were still based on the employee's wages. But in the late 1970s, juries began to award compensatory damages, damages for pain and suffering, loss of dignity, and punitive damages. By the 1980s, the average award grew to well over $300,000, and verdicts have gone as high as $17 million.
As late even as 1979, wrongful discharge lawsuits really weren't that common. Only about 200 a year were filed at that time. That's not true today. Today, more than 20,000 of those lawsuits are filed every year. Now, most of those will be dismissed or settled before they get to full trial, but all of them will entail lots of expense and lots of trouble for the employers who are sued.
Well, you get the direct costs, which of course are the benefit costs and the settlement costs. But I'll tell you what most people are upset about is all of the hours that need to go into talking to lawyers by senior management people in many cases, when they could be using this time to strategic planning, redefining what the company should be doing. It's high valued time that's lost. And there's no easy way to put a dollar figure on that.
These days, almost every discharge constitutes a potential lawsuit. Given the litigious nature of American society, it's virtually impossible to develop a framework where an employer will be totally safeguarded from unwarranted wrongful discharge suits. However, it is possible to take precautions that will limit your exposure and increase the likelihood of successfully defending yourself should you end up in court. Now let's see how Zykor and John Martin got into this situation. Listen carefully to the testimony the jury relied on to arrive at its verdict, and note some of the mistakes that John made along the way.
Mr. Nelson, please tell the jury your educational and employment background.
Well, after I graduated from high school, I held several jobs doing mechanical work. I learned basic mechanical drawing and machine tool design. I guess that was about my wife and I didn't think we could afford to have children on the salary that I'd be making as a mechanic, so I took out some student loans and graduated from college with honors. After I graduated, I went looking for a job where I could use my degree. In fact, Zykor initially recruited me on campus. And then after another meeting at their offices, they offered me a job. And I've been working for Zykor for the past 10 years. Well, after the initial interview on campus, I went down to meet with Mr. John Martin.
Mr. Martin, what kind of future can I expect if I come to work for Zycor?
Pete, this is a great place to work, and we're growing. If you do a good job and stay out of trouble, there's an opportunity for a terrific career. You could stay here and grow old like the rest of us. Only a handful of people have been let go, and they've gotten plenty of notice. Come on, I want to introduce you to the rest of the team.
Okay.
He said that I could have a career with Zycor. Look, John Martin promised me a job for life. He said that I wouldn't be fired without just cause, and that if I was going to get fired, that I'd get written notice.
As you can see, seemingly innocent language used in a hiring interview can often come up later in a wrongful discharge suit. Loose or ambiguous language can have damaging effects when fired employees claim they interpreted the words as a promise by the company of an employment contract subject to a just cause standard. In other words, that they would not be fired without a good reason. For example, when an interviewer characterizes a job as one in which the applicant can stay and grow, he or she creates an implied contract of lifelong employment. So phrases to avoid include life, career, and written notice. Like the pre-employment interview, your company's employee handbook can work either for you or against you.
Peter, I'm bringing you a book that has been previously marked by the court as Plaintiff's Exhibit Number 1. Would you review that and tell the jury what it is, please?
This is a copy of the employee handbook that I was given when I first went to work for Zycor Corporation.
Turn to page 12 of the handbook and read to the jury the section entitled Employment Termination.
Employment can be terminated at any time for just cause. However, it is our hope that every employee who joins the company will stay until retirement.
Is just cause defined in that handbook?
No, it's not.
Were you terminated for just cause?
No, I was not. Neither Mr. Martin nor anyone else ever told me that my work was unacceptable. I believed it was satisfactory. They should have given me some kind of warning. It's just not fair.
Again, seemingly innocent language can be very damaging. A good handbook informs employees quite directly that their employment is strictly at will, and that no one short of the president of the company is authorized to make any promise contrary to this. In fact, the handbook should be used to negate any possible implied promises of long-term employment.
Having a good handbook is really important because it gives employees an idea of what's expected of them and what they can be disciplined and terminated for. And it's also important for supervisors and managers because it lets them know how to treat people the same, regardless of their race or sex or religion. And that's important, obviously, for avoiding discrimination claims and things like that. And also for morale, so that everybody feels treated fairly.
Another common exception to employment at will is a situation where a company requires an employee to violate the law in order to keep his or her job.
Well, one day about 3 months before I was fired, John and I were discussing a memo that the president of the company had sent down to the engineering department. It had to do with delays in the schedule on a project that I was in charge of.
So, Peter, did you get the big guy's memo on project delays?
Yeah, I got it. Look, I know we're behind schedule, but a lot of those welds are just not up to spec.
Look, Pete, this is the real world, not engineering school. The client is furious about these delays, and my ass is on the line. You can bet if mine is, yours is too.
What the hell do you want me to do, John? I can't approve bad welds. Look at those cracks. That's just not right.
Look, I don't have time to argue about splitting hairs, all right? If I were you, I'd get this project moving before the old man sends somebody down here who can. Now, I don't care how the hell you do it, but I need that job finished yesterday.
I was shocked that Zycor wanted me to go around the regulations and break the law. We could have had a serious accident because of those bad welds.
Did you take the time to redo the welds?
I sure did, but I didn't think I'd lose my job because of it.
There are really two broad ways in which a discharge can be found to violate public policy. One is where an employee is fired for refusing to violate the law, but the other is where an employee is fired for trying to exercise rights protected by the law. An example of that would be an employee tries to fulfill his civic duty to serve on a jury. If an employer terminates the employee for that, in most states that will be found to violate the public policy of the state. Another example would be where an employee tries to report to a government agency a perceived violation of government regulations. This so-called whistleblower is protected in many states, and an attempt to discharge or punish an employee for this so-called whistleblowing is often found to violate the public policy of the state.
Another area where employers must be careful is in connection with workers' compensation claims. In most states, it would be a violation of public policy to fire someone for filing a workers' compensation claim. There are some states, of course, where there are actual laws which prohibit that. But in most states, it would be a violation of public policy to keep someone from exercising a right that they've been granted under a statute that's protective of them.
In addition to the two situations we've just discussed, many states now allow a fired employee to challenge not only the reason for termination, but how the termination was carried out. These suits challenge an employer's conduct under legal theories called torts and can result in special jury awards. One such special award is punitive damages. Now, the primary purposes behind punitive damages are punishment and deterrence. Juries are often made to feel they need to award significant amounts in punitive damages in order to send a message.
We, the jury, find for the plaintiff, Peter Nelson.
What the jury is being asked to consider is what would it take, how much would it take to punish the offender. The employer has no idea going into trial what the jury may feel is necessary to make the employer feel hurt.
The thing that you find out is that at trial, even things that you might not think would work against your interest or the interest of your company can be used by a plaintiff's lawyer to really make you squirm. Information about how big the company is, how much the gross sales are, even things about a manager, what kind of a house you live in, or what kind of a salary you make, can all get into evidence. The jury can think about it, and the arguments that you don't want to hear but that you will hear are, look how much money this company is worth. Look how much money this manager makes. And what's it going to take to make them sit up and take notice? The issue that you wind up dealing with there is punitive damages.
That was the case here, where John was held personally liable. Peter claimed that John defamed him and asked the jury for punitive damages for defamation. Now let's see how this defamation count arose.
Well, Mr. Martin came in for lunch on that day with two other managers from Zycor.
Okay, that's 2 tuna on rye and a ham and cheese on whole wheat. Hey, where's Pete Nelson been hiding himself lately?
Old Pete exercised a career option.
Huh?
Yeah, we had to let him go.
You're kidding. What for?
Well, to tell the truth, he just couldn't handle it anymore. Maybe it was booze, problems at home, drugs, who knows? Some people just can't cut it.
Tell the jury the reason Mr. Martin told you that he fired Peter Nelson.
Well, he said it had to do with alcohol and drugs.
You need to know where conversation ends and gossip begins. Idle comments can lead to great legal problems.
You've probably heard that truth is a defense to a defamation action, and that's still the law. Unfortunately, many truthful statements can also lead to liability.
Something may be true. You may have fired an employee because you suspected him of theft. And if you say to another person, well, we fired poor old Joe because we thought he was involved in some stealing or some gambling or any kind of illegal activity, that might technically be true. That's what you thought. But you can't prove that he was actually doing it. On the other hand, the person that hears you say that may at some time later say, yeah, they fired him because he was stealing. And if you get drug into court trying to prove that that was true, even though you thought it was at the time, it could be a bad day for you.
One of the more crucial situations a manager faces is the discipline and discharge or termination of an employee.
Well, one needs to remember that it's an emotionally charged atmosphere, that it's entirely possible that an individual may become defensive to react emotionally. And should that occur, then the manager needs to maintain composure, to be professional, and to permit that to happen without getting defensive themselves or getting caught up in that. You certainly don't want to contribute to the individual's anger, because if they get angry, then they're going to want to take some recourse. And that not only might be with the company, but it might be with the manager too.
So this is the thanks I get for 10 years of hard work?
Ah, don't be an idiot, Peter. Lately you've been inept, unreliable. Geez, I could hire people off the street and get more out of them. I don't have time to babysit a lazy department head anymore. We're going to give you 2 weeks severance pay. Yeah, I'm sorry it didn't work out.
At the meeting where John Martin fired you, what exactly did he tell you about your performance?
All of a sudden, he called me an idiot. He said I was lazy, unreliable, inept.
Just a few weeks earlier, you had had a performance evaluation. What did he tell you about your performance then?
Pete, your performance just isn't what it should be. You're really going to have to start to buckle down and start producing.
Well, I promise you, John, I'm going to try harder.
Well, hey, I know you get along well with the other people in the department. I also know you're a team player. So, come on, let's see if we can't get everything back to your usual excellent work, okay?
Okay.
Okay, see you later.
All right. I never had any warning that my work was not satisfactory. At my last performance evaluation, John Martin told me that I was doing an excellent job and that he thought I was a real team player.
As we've just seen, failure to provide evaluations in a direct, candid, and accurate manner can give rise to costly legal actions. Too often, a manager who attempts to fire an employee for poor work is confronted with performance evaluations which all report the employee's performance was either good or satisfactory. Evaluating an employee's performance is no place for a snow job. Too much concern with keeping peace in the workplace can lead to maintaining unproductive workers and potentially expensive liability for the employer.
One of the problems that we see regularly with these evaluations is that they're what we call inflated. The individual is generally evaluated above his level of performance. I believe this occurs because the supervisor, although he or she may be a supervisor, works regularly with the employee on a daily basis. And I think we all have a lot of trouble sitting down with someone we might have lunch with and telling them they're not doing a good job.
But being friendly doesn't mean that you should soft pedal or not provide clear information about performance so that they know how they're performing. If they don't know that, then they can't correct it. And that leaves all kinds of room for misunderstanding.
I have literally been asked to defend a discharge of a salesman who was fired for poor performance, who had been awarded the Salesman of the Month award just 2 weeks before. You can imagine how hard it is to convince a jury that that discharge is fair.
So, what have we seen so far? Well, certainly being a manager today is far more difficult than it was even 10 years ago. The stakes are much higher.
For an employee making about $50,000 a year, the expected jury award will come in at about 3 times that, and that's just for lost wages. Where tort theories are involved, it's far more expensive.
Now, we're not just talking about contract damages. We're not just talking about back pay. We're not even just talking about punitive damages, which and sometimes you're afraid that the sky is the limit. We're also talking about compensatory damages. That means the pain and the suffering that the plaintiff's lawyer will paint a great picture of for the jury. It can mean the humiliation, the embarrassment, the emotional distress. Those are the terms that you hear about. Those are the items that you worry about how to disprove. How do you disprove it if somebody claims he couldn't sleep, or he was too embarrassed to face his kids, didn't want to go to church anymore, those kinds of claims. What it comes down to is there's a great unknown whenever you get into litigation and you get in front of a jury, and these kind of issues are brought up, and it's all focused against how much is this company worth in the first place?
Imagine, if you will, how this man felt when he was summarily fired and had to go home and tell his wife and his child that he'd been fired. He had no job. Imagine, if you will, how this man felt in the community when his friends found out that he'd been fired. His co-workers found out that he'd been fired. What could they think of him? What's the matter with this man? Why was he fired? You know, having sat through 3 days of this trial, that there's nothing wrong with this man at all. What's wrong is wrong in the Zicor Corporation. You as jurors have the opportunity, the duty, and the power to correct this wrong. How do you go about doing that? You do it by stinging them where it hurts in the pocketbook. The only thing that this corporation understands is money, dollars, and they've got plenty of them. $45 million to be exact. That's their net worth after all their debts are paid. We suggest 5%, 5 cents on the dollar, approximately $2 million in punitive damages against the Zicor Corporation to send a message to their executives, their managers, their Mr. Martins, that they can't treat other employees like they have treated Mr. Nelson. But you need to go beyond that. It was this Mr. Martin who broke his promise. It was this Mr. Martin who slandered Mr. Nelson in the community, who caused him the intense pain and suffering that he has had. Something must be done to get his attention as well and to punish him as well. How much? What should be done? He's a mid-level manager. He makes $85,000 a year. Mr. Nelson makes nothing. He's out of work. He lives in a $125,000 house. Mr. Nelson has lost his house. He has a vacation home, a boat. He lives the good life. Something must be done to get his attention. I suggest to you that $50,000 taxed against Mr. Martin, not against the corporation, but against Mr. Martin, would be fair, just, equitable punishment to see that he doesn't do this again and that other managers get the message that they can't do it again and hide behind a corporation. Thank you very much.
We, the jury, find for the plaintiff, Peter Nelson, on all counts.
Win or lose, the employer has to pay the cost of mounting a legal defense against an employee-brought suit. In a vigorously contested case, those expenses could easily exceed $250,000. Now, you might be asking yourself, how will I be able to manage if I have to worry so much about what my employees are doing? I can't possibly document everything that happens during the day. What can I do that will keep me safe from such suits, but will still leave me free to manage? As a manager, you have a difficult problem to simultaneously motivate and discipline employees. You must be able to get the best person for the job, yet still stave off disaster. Lawyers can't run your business. You have to be the best manager you can be. Now let's look at the areas we've already covered and see how to handle each one in the most effective way. Here's one way in which John could have handled the pre-employment interview in order to reduce the likelihood that Peter would file suit against both himself and Zicor.
Peter, as an electrical engineer for Zicor, you'd be working in our quotations department. Now, we get in plans for wastewater plants all the time. According to your job description, here's what it says. You would be expected to estimate the costs and prepare a bid for the telemetry control systems within. The nature of your employment with Zicor would be at will. Now, that means that you can quit at any time and for any reason that you want it. And Zicor would have the option of terminating your employment for any reason and at any time. Now, let's discuss exactly what both our expectations are concerning the position, all right? Okay. Let's also look at specific job standards and how the company will evaluate your performance. Now, you'll have a formal review every 3 months, but we'll be talking about it a lot more often than that.
Notice how John did not make any promises or try to predict the future working relationship. He simply stated the job duties and general company policy. An employer's vulnerability can begin in the very early stages of an employment relationship. It's important to be upfront and truthful from the very beginning. For example, a manager must examine the reasons for hiring someone and be totally honest with the applicant about the job and what's expected of them as an employee. Stay away from making any kinds of promises or offering any superfluous information. It just could lead to trouble. Now let's see how John should have handled the incident with the bad welds.
So, Peter, did you get the directive on the project delays?
Yeah, I got it. Look, I know we're behind schedule, but a lot of these welds are just not up to spec.
Look, I know we're having problems with the subs, but we really have to move this along. The client is furious about these delays.
John, what do you want me to do? I can't approve bad welds. I mean, look at these cracks. It's just not right.
I understand your point, but it was your responsibility to see that the job was done right the first time. Now, you know it's company policy to deliver to exact specifications and meet all regulatory requirements. So if these welds are bad, they'll have to be redone. But let's speed up the job and meet the specs, okay? Now, I want a full report and a revised schedule ASAP, and I want to meet on Friday to discuss this in more detail, all right?
Okay.
Never insist that an employee break the law. John simply stated the company's policy towards the regulations and his desire to move the project ahead. Now let's see how John should have handled the incident at the coffee shop.
2 tuna on rye and a ham and cheese on whole wheat. Hey, where's Pete Nelson been hiding lately?
Well, Peter is no longer with the company.
You're kidding. Well, I thought he was one of your fair-haired boys. What happened?
Marcia, it's against company policy to talk about our employees or former employees, but we will need 2 iced teas with lemon, please.
Okay, you got it.
Okay.
Once again, it should be company policy, and it's certainly common courtesy, not to discuss employees or former employees, especially with people who don't need to know. Now, here are some simple rules to help you avoid finding yourself in a defamation action. Only make statements which are true, or which you have reason to believe are true. Only make these truthful statements for a business purpose. Limit your statements to just what is needed to serve your business interest. And make the statements about employees only on proper occasions and to individuals who need to know. If you'll stick to these simple rules, your statements will most likely not generate litigation in the first place. And if they do, your chances of winning that litigation are much better. Now let's look at how John could have better handled the performance review.
Peter, I called you in today to discuss your performance over the last few weeks. I've talked to you before about meeting deadlines, and you've corrected the problem almost every time, but lately, you're missing deadlines right and left. Now, we just can't tolerate this, Pete. It impacts on every other department in the company, and headquarters is starting to ask questions.
Look, John, I've been having some personal problems, but I think they're all taken care of now.
I'm sorry you're having troubles. Let me know if there's anything I can do to help you personally. But today, we really need to focus on your work performance. Now, let's go over some of the goals we set for this quarter.
Okay.
It's important that employees receive straightforward evaluations that simply and realistically assess their performance against established standards. In these evaluations, as in all our dealings with employees, you must focus on work behavior and not personality.
I'm going to give you a written notice, which I'd like you to sign, indicating that you understand what we've just discussed.
Okay. Okay. Yeah, I understand. And I plan to do a lot better.
I hope so, Pete. If things don't improve within the next month, and we might have to take more drastic action. And I certainly hope it doesn't come to that.
What do you mean by more drastic action?
Well, we don't like to talk about termination, but if the performance goals we both agreed to are not met, then we may have no other choice.
No, I understand.
Okay, so we're clear on this. Let's go over exactly what's needed for improvement.
Okay.
See how John was? Very straightforward, no small talk. He stuck to the point of the review and was clear and concise. There was no question about the fact that Peter had problems with his work. Now let's see how John could have better handled the termination. You'll see he treats Peter as he would have wanted to be treated by the company.
Good morning, Peter. I've asked Miss Johnson to sit in on this meeting. We're going to have to let you go, and I want to tell you why. Now, this isn't something that happened all of a sudden. It came after a lot of thought, and it was a very difficult decision. I've had you in my office twice during the past 2 months, and we've discussed your performance problems. We both set goals for improvements that have not been met. I warned you then that if your performance didn't improve in certain specific areas, that I'd have to take drastic action. Now, these are copies of my warnings to you. Peter, this is a very uncomfortable situation for both of us. And your performance just has not improved. In fact, I'm afraid it's gotten worse. Now, I've discussed this with the personnel department and my immediate supervisor, and we think it's best that we terminate your employment with the Xicor.
But I've been here so long. Come on, John, you've been on my back all year. You just don't like me.
Peter, please, we're talking performance here. I've enjoyed our working relationship. I think you're a fine guy. But it's clear that we've discussed it, and after going through your performance, it's the final decision.
No.
Pete, let's take a look at your termination benefits. I'm sure you'll agree that they'll offer you a fair amount of security while you're searching for another job.
As you see, John followed all the appropriate guidelines for avoiding a wrongful discharge suit. First, he discussed Peter's dismissal in advance with all appropriate parties. Then he prepared an agenda, collected all relevant documents, and scheduled a meeting for an appropriate time. He got right to the point and made no small talk that could be misunderstood. He gave a business-related reason, and he explained the company's severance policy, and then ended the meeting. Now, it might seem that no matter what you do, no matter how careful you are, right or wrong, disgruntled employees will still be able to take your words and twist events to bolster their case. But if you deal honestly and fairly with the people you manage, there's less chance that they'll feel a need for vindication through a lawsuit. Treat all employees with respect, and don't give vent to your emotional spleen.
You're not in that situation to serve yourself or to make you feel good. You're there to represent the company, and you're there to give objective information that's going to be helpful, hopefully, to the employee.
Here are 3 very basic preventive measures that every manager can take. Document all disciplinary action meetings or termination interviews. Have a witness sit in on any important employee-employer meetings. And always treat all employees with respect and dignity. But even if you're still faced with an employee suit, the truth will be your ally.
Mr. Nelson, you testified earlier today that in your interview with Mr. Martin, you asked what your future could be at Xicor. Do you remember that?
Yes, I do.
Well, do you also remember that during that interview, Mr. Martin told you that your employment would be at will? And by that I mean use the words at will.
Yes, that's correct.
Didn't he go on to explain to you what at will meant? That is, you could quit the job at any time for any reason? Is that correct?
Yes.
Wasn't there a reciprocal right that he also explained? That is, the company could terminate your employment at any time for any reason.
Well, yes.
Didn't he in fact say that it was company policy to meet all regulatory specifications?
Well, yes.
And isn't it a fact that he said if the welds weren't done properly, then they would have to be redone? Didn't he say that to you?
Yes, he did.
When you asked Mr. Martin about Mr. Nelson's departure from the company, isn't it a fact that he told you he couldn't talk about employees or former employees because it was against company policy?
Yes, he did.
And didn't he also say that your performance and your missed deadlines was impacting every department in the company?
Yes, he did.
And during that last evaluation, didn't Mr. Martin also give you this written warning about your performance?
Yes, he did.
And that is your signature on the bottom acknowledging receipt? Is that correct?
Yes, that's correct.
Thank you very much.
You see, simply telling the truth can work for you. Now, before we review, there are some important things to remember. As a manager, you need to understand what you and your supervisors can and cannot do. Every company has different policies, and as we mentioned before, laws in every state are different. If you have any questions about your company policy, consult your personnel department, the legal department if you have one, or your manager. Now, let's review what we've talked about. First, look over your pre-employment materials dealing with recruiting, interviewing, and hiring. These documents should not contain any suggestion that prospective employment will be for a definite term or that employment will be terminated for just cause. Make it clear to the applicant that the employment relationship, if one is entered into, will be terminable at will. Recruiters, managers, anyone involved in interviewing prospective employees must avoid making statements that may not be accurate or true. You must not make any promises regarding career opportunities, future compensation, length of employment, or expected job duties that cannot be kept. And at the end of the interview, make sure you ask all applicants if any promises were in fact made to them by any company employees they talked with during the hiring process. If the answer is yes, advise them not to quit their current job or turn down any other job opportunities until those promises can be verified. At this point, you must verify their expectations and assumptions. You need to get feedback and clear up any misconceptions they may have about the job being offered. Another area for review is your performance evaluation and discipline process. Here are some points to consider for effective management in this area. Develop a regular schedule for formal evaluations. Evaluations could be performed on an annual basis or more frequently if desired. But remember, performance evaluation itself should be a continuous process with constant communication as well as periodic formal meetings. Communicate to your employees the standards for each job. That way, employees will know what is expected of them and they can measure their performance against specific criteria. Promptly correct any employee performance problems and handle all employees equally and fairly. Give the employees an opportunity to respond in writing to their evaluations. However difficult, take the time to document any evaluations, investigations, or discipline meetings. Document problems as they develop. Don't wait until it's time to terminate the employee before you attempt to reconstruct events that may have happened in the past. Ask employees to sign the evaluation form at the conclusion of the meetings. This indicates that they understand the document and give employees an opportunity to respond in writing to their evaluations. Perform a periodic review of completed evaluations. This ensures that they are realistic but fair. You must have the personnel department review and/or approve all major disciplinary actions. One person alone should not make the decision to terminate an employee. Remember, when evaluating an employee's performance or administering discipline, be careful to limit your comments to the employee's conduct rather than to his or her personality. Unnecessary statements which damage an employee's sense of self-worth serve no useful purpose and may cause an employee to seek vindication. Plan and conduct the termination meeting like any other important business meeting. Prepare an agenda and have on hand all important documents. Get immediately to the termination. Give a concise business-related reason. Handle the details of severance, company policy, and company property, and conclude the meeting. You must continue to exercise discretion after an employee has been terminated. It's good to have a written post-employment reference policy. If possible, respond only to written requests for information about former employees, and only after verifying the individual's need to know. It's also advisable to document all information provided in response to a reference request. Use your authority to manage your employees, not for personal gratification. Everything you do must have a legitimate business purpose. It's important to handle discipline and termination with dignity and respect for the employee. Remember that your job is to be a manager.
Well, I think companies that have found their ability to avoid a lot of these litigation problems are companies, first of all, that spell out what is required of employees and what they expect of them immediately as they come into the workplace. And then, in addition, maintain good lines of communication between management and the employees.
It's important for a manager to treat an individual as a human being. So I think one needs to start out with sensitivity and caring and respect for that human being. You may disagree with some of the things they do. You may not like some of the things that they do. You need to understand that they may do it differently from you.
Listen to what the employee has to say. There's two sides, as we all know, and what the employee has to say may not change your mind, but the fact that you listen to him and consider that makes a big difference.
Discipline people fairly, document what you do, communicate with your employees, and in general, let them know what's going on and what's expected of them.
With a little attention given to conducting yourself properly in the employment relationship, you can turn your attention where it belongs, and that is doing your job, managing your business.
Now, let's sum up. Here are the general guidelines that all managers should consider carefully. Be fair and truthful. Remember, your actions and statements can cause problems down the line. Monitor employees for potential problems and give accurate, honest, and timely periodic evaluations. Keep good documentation, especially when an employee receives discipline. Let employees know of the consequences of their behavior. Communicate the standards you expect them to meet, and make sure that they get the proper training to do the job. If job performance falls below expectations, immediately advise the employee precisely where they are deficient and what must be done to improve performance. Firmly enforce your rules of conduct and work performance standards. Treat all employees equally and apply all rules uniformly. If an employee is in danger of being terminated, give fair warning that his or her conduct is not acceptable. If you must fire an employee for an unusual circumstance, like theft, seek additional advice. Plan and conduct the termination meeting like any other important business meeting. Be careful about any post-employment comments or referrals. It all boils down to the golden rule. Treat the people you manage the same way you would like to be treated. If you think things through and follow these guidelines, you should be able to effectively manage a quality workforce well into the future.